Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. How you guys doing today? All right, so it's been a while since I spoke on Mr. Livingston Allen, aka DJ Akademiks. So, as you all know, I have done videos in the past regarding his two essay lawsuits as well as the dog bite case. And I just wanted to give you guys a general update on his case status. So, let's hop right on into it. All right, so this first case, this is the one that we have been in the past seeing him go on podcasts and talk about, it didn't happen and blase, and that he beat the case. Y'all, I'm going to be honest with you guys. There could be so many technicalities that will cause a case to either be dismissed. Um, and this is one of those cases. I hate the fact that people will use that to their advantage and be like, well, I beat the case. And it makes it seem as if the injured party or the plaintiff was lying. And that is not the case. If you have not or not are not aware of what's going on in his cases, please go back and watch my previous videos so that way you can get caught up to date with it. But for Miss Sophia, and I don't want to mess her name, I believe this is one of the first essay cases that was filed. There has been a lot of activity since 2022 when she initially filed, and her case ended up being dismissed, and then she went to appeal it. And I'm going to explain the appeals process once I show you guys the docket. So here, it was initially filed on the 22nd. The defendants were Mr. DJ Akademiks, as well as Antoine Mason and Jalen Lilly, aka Little Boom. I have no clue who that is. But it doesn't even show that Antoine or Jalen are represented by anybody. It does show that DJ Akademiks does have representation. Let's see. Now going to here. So this is to kind of sum up everything. Like I said, she filed suit on, as you can see, July 12th. Service or the summons was issued on the same day. Okay. What you see here are the affidavits of service, and this pretty much is just not an outline, but a timeline of when the process server has been trying to not get in contact, but serve the defendants with a copy of the complaint. For DJ Akademiks, okay, I'm going to pull this up. All right, so for him, it shows that the process server made diligent efforts to serve him personally in July, on July 22nd, July 27th, and August 1st. Because it could not be made, what they did was on August the 4th, they affixed the summons and a copy of the verified complaint at his usual place of residency. Then on the 5th, they also dropped it in the mail. Okay, so anytime you post it to the door, you always have to make sure that you drop it in the mail. Now, I don't know too much about how New York does theirs, but anytime we are unable, and I'm speaking for Texas, I'm speaking for Florida, because I've done cases out of Florida, even in California, when we're not able to serve them personally, we have to file a motion for substitute service. So we have to get permission from the court in order to, you know, put it on the door, serve it to somebody who is 16 years or older at the house, whatever the case may be. I don't see that happened. All I see is that they tried to do it. They tried to serve them personally, face to face. And then, that was 2-3 days later, they put it on a door and then they dropped it in the mail, USPS. Why they did that, I don't know. I have to go back and check the summons to see if that is, if they're allowed to do that. But that could mess up the process too, because the defendant can come back and say they weren't properly served, and then that can throw out the case as well. So you have to be careful with that. All right, so that is when he initially is supposed to be served. So he got served on the 4th of August, which means he has anywhere from, and once again, this is New York, so I'm not familiar with the summons date. You have, you know what, I'm saying that and I could just click on it. All right, here's the summons. So they have 20 days. They have 20 days from the day that they were served. And it clearly states, in case of your failure to appear or answer, judgment will be taken against you by default for relief demanded in the complaint. I'm just saying. All right. So he had 20 days from August the 4th. All right. So I don't see anything indicating that he answered. So what she did is she went ahead and entered in a motion for default. So he was served, but he didn't answer. So she gets to put in an entry for default. So she did that. She provided her exhibits, which will include her summons and complaint showing that they did, in fact, try to serve him and they did serve him, so on and so forth. So she put that in on November 23rd, 2022. Let's see. Then here comes August, notice of appearance, stipulation. All right. So then, and I don't see that it's on here, and I don't know why, but the judge did end up granting that. But then here comes DJ Akademiks filing the opposition to the motion. So he's saying, I am opposed of this motion for default judgment. Can you please grant us additional time for me to answer? So this is not an answer. This is just him opposing the motion for default. So he submits all of his evidence. So the fresh and fit transcript, all of these exhibits, the podcast transcripts, because he was talking mad noise on that podcast. Then we have a notice of cross motion, and then let's see. Then I'm skipping, and then we have an order of dismissal. Let's see what that says. So in this particular order of dismissal, upon foregoing papers, it is ordered that this motion by the defendant, so remember it was a motion opposing the default judgment. So what the judge did was said, okay, we are going to vacate his default in answering and appearing and extend his time to answer, and dismissing the complaint and other relief is decided without opposition as follows. So plaintiff commenced the instant action to recover damages for defamation, intentional infliction of emotional distress, injurious falsehood. Make this bigger so you guys can see it. Where am I at? All right, defendant Livingston Allen failed to timely serve an answer. Defendant now seeks to vacate his default in answering and appearing. Under CPLR 3012D, the court may extend the time to appear or plead or compel the acceptance of a pleading untimely served upon such terms as may be just and upon a showing of reasonable excuse for delay and default. In addition to compel the plaintiff to accept a late answer, a defendant must provide a reasonable excuse for the delay and demonstrate a potential meritorious defense to the action. This is funny. So here's the excuse. At bar, the movement has set forth a reasonable excuse for the default. According to the defendant, when he returned from traveling in August of 2022, there was no package or envelope containing a summons and verified complaint affixed to his front door, as alleged by the plaintiff. Defendant further avers that he discovered the summons and verified complaint in a weathered stack of papers on the lawn by the side of his home while walking his dog in November 2022. So, y'all, do y'all believe this? He was served on August the 4th. Well, I wouldn't even say personally served. The summons and the complaint was on his door. He went to walk his dog in November. And that's where he found the stack of papers. So you telling me that during that time you didn't cut the grass or had nobody cut the grass or you didn't go out? I'm having a hard time believing this. But it's crazy because I'm going to show y'all in another case where they actually took, and that's why I like process servers that actually take pictures, because it could say, bam, I took a picture of this, so you can show that I did, in fact, posted this summons and complaint to your door, because I don't need you coming back say I didn't properly serve you. But anywho's, he found the papers in November, so August 4th to November. That's August, September, October, November. That's 3 months. But okay. He also states that he promptly acted to secure counsel when he was made aware of this action. In addition, the movement set forth a potentially meritorious defense to the action via his affidavit of merit. Or currently, the branch of this motion by the defendant Livingston Allen to vacate the default judgment is granted without opposition, and the default of the defendant Livingston Allen in answering and appearing is vacated. So it's pretty much meaning that the order to grant the plaintiff with a default judgment against DJ Akademiks is now void. And they are giving him time to serve an answer within 30 days. Ain't that crazy? That is crazy. So the motion to dismiss the complaint is denied. So they did deny his request to dismiss the whole lawsuit, which is good. Oh, now this is crazy. So here's the order. September 29th. And they filed it on 10/16. That's why I was like, what? All right. So that is that part. So now we're going and we are filing. And he ends up filing everything exhibits. Same thing that he keeps filing. He's still trying to file a motion to dismiss. So let's see, memorandum. And they have them numbered. That's why I really hate going through New York stuff. So anywho's, kind of going through here. I'm trying to sum it up. So I'm going to go straight to the order, right? All right. So here on this particular one, all right, so it says, upon the foregoing papers, it is ordered that this motion by the plaintiff for default judgment is decided as follows. It shows that At the outset, the court notes that the pursuant to an order dated, so we just read that order. So that order vacated the default judgment, right? So at the outset, the court notes that pursuant to an order dated September 29, 2023, this court granted the motion by defendant Livingston Allen to vacate his default in answering and appearing and permitted him to serve an answer within 30 days after service of a copy of the order with the notice of entry. As such, the branch of the motion for default judgment as against defendant Livingston Allen is denied and mute, because that means that he has already been served and he filed his answer, so on and so forth. Now, the branch of the motion for the default judgment as against the remaining defendants will now be considered, meaning that they also were served, but they did not file they didn't respond to the lawsuit. Let's see. It is well settled that on motion for a default judgment, a plaintiff shall submit proof of service of the summons and a complaint and proof by affidavit of the facts constituting the claimed default and the amount due. So that's all that she has to do. So the default judgment, and I explained this in the previous videos if you want to go back and watch to get more detailed. So as of now, it is a default judgment against Antoine and Jalen. So the motion by the plaintiff for default judgment is granted against those two and not DJ Akademiks. So that goes to the next phase, and I'm going to go back. So keep that in mind. The judge vacated the default judgment against DJ Akademiks. Now, we know that story is BS, that all of a sudden you found the paperwork outside 3 months later. I don't buy that at all, but it is what it is. So with that being said, the attorney said, okay, no, we are going to appeal that. And the whole reason for appeals is for the appeals court to look at the decision the lower court made. And the appeals court duty is to say, did the trial court make a justifiable decision? Were they right in the way that they ruled? And so they have to look at all of the evidence. And that's what she filed on 4/26/2024, her notice of appeal. And as of right now, let's see, they have plaintiffs, appellants first. So they're asking for, I'm pretty sure it's a lot going on. So they are asking for extensions. I'm telling y'all right now, when it comes to writing briefs, I used to do that. And I stopped. Because Bree, go to an attorney. Please go to an attorney. I don't want, if somebody say, nope, I can't do it. Because it's the way that you have to structure it. And it has to be on point. Because even if it's off, for example, I'm showing y'all this. This is the appellant's brief. So here, this is DJ Akademiks, if I'm not saying. This is his attorney. Oh, no. It says brief for the plaintiff. Okay, the respondent. The table of authorities, the preliminary statement, the questions presented, the statement of facts. And so here, and this is how you have to set this up. So what is the issues that the Court of Appeals need to look at when they're reviewing the lower court's decision? Did the lower court, in its order dated September 29, 2023, err by overlooking appellant's opposition to respondent's cross motion to vacate his default and ultimately grant respondent's cross motion without considering the appellant's arguments? Did the lower court abuse its discretion in determining that the respondent, despite him not proffering specific and detailed facts in his affidavit of merit, rebutting proper service and failing to provide a substantial basis for what a meritorious defense had a reasonable excuse and meritorious defense sufficient to vacate his default. That is the thing, because I am looking at, you're telling me that you discovered these papers 3 months later on your lawn, lower court. Really? Really? So, as of right now, and I'm pretty sure that his attorneys is probably going in overtime trying to get this brief together. So on August 29th, I think, I already looked at this. They are asking for a 30-day extension. So it says, Allen respectfully requests until October 9th to file his response brief on the account. Oh, so he has, 2 more days? I don't know why I thought today was the 9th. So he has 2 more days, because I really want to know what it is that he said. All right, and that doesn't show me anything. So they gave him an extension. So we have 2 days to see if he responds, because I am very interested to see how they're going to prove that he was not properly served. I really want to see that. So that is that case. That is that particular case. So for this SA case, he did not beat this case. What he is saying is that he was not properly served. Now, we know that that man was properly served. You just failed to file your answer in a sufficient manner within that 20 days. She really deserved that default judgment. But the Court of Appeals is going to look to see if the trial court, if the Queens County Supreme Court did what they were supposed to do. Now, let's head over to New Jersey. So New Jersey, he has his second SA case as well as the dog bite case. So I'm going to go into the first one. Bashi, I do not know how to say her name properly, and I do not want to butcher her name. I got to sign back in. Oh. All right. So while I am doing this, what are you guys thinking about this? Because I am just really floored that he could talk about everybody else's cases, but he doesn't discuss his. I mean, I get it. He probably can't say too much because it's in litigation. I think that's the excuse that he is actually going to use, but it's like, bro, come on. I'm about to type in my name. All right. Now, going into the second SA case that was initiated on May 13th, 2024. I think the last that we came, it was an amended complaint. Stipulation to extend time for answer. All right, so he entered. So he filed an answer on the 9th of September. And let's pull that up. Oh, and this is what I want you guys to see. Now, in New Jersey, whoever this process server, they did what they were supposed to do. All right, so that's one thing. I could have sworn one of them put their took a picture. Oh man. I thought it was this case. It was probably the dog bite case that they actually showed a picture of them posting it to the door, and I'll look at that so we can see. But anywho's, he ended up getting a lawyer and he filed his answer, and I'm pretty sure he denied all the allegations and put everything on the plaintiff. That's usually what they do in these type of cases. Unfortunately, it's sad, but that's standard. Oh, he has affirmative defenses as well. All right. So as we can see, he denies the allegation. Now, let's do something. We're going to put it face to face. Amended complaint. let's see. Hopefully you guys can see that. Try to do like a double screen. Oh man. Okay. This is how I'm going to do. I'm going to do this right first. Yeah, so y'all remember that? He just looking crazy. Factual. Oh, how they got this is crazy. So these are all the factual information. Trying to get down to the causations. That's if they even labeled it like this. Yeah, first cause of action, negligent infliction of emotional distress. Okay, so let me see what they put into this one. All right, so it says defendant denies the allegation that defendant contacted the plaintiff. Defendant denies the allegation that the defendant, Allen, contacted the plaintiff. The defendant admits that the defendant sent a car to pick up the plaintiff and that the plaintiff had been to the defendant's home before. With regard to the remaining allegations, the defendant is without knowledge sufficient to the form of belief as to the truth of the allegations contained in paragraph 1. So remember, this is the case where she went over there, and remember all the lights were off, the power was out or something, and he claimed he was asleep in his room, and the other two gentlemen that was there ended up essaying her outside in the pool area. And I know that you guys seen when I was scrolling through the complaint that you saw that image. That's this particular case. So what he's saying is he's not going to say that he did call her, but he does admit that he sent a car to pick her up. How do you send a car to pick somebody up but you don't contact them? That's weird. That is weird. Are you saying that you don't remember? I think that's what he's trying to say, that he doesn't remember talking to her, but he does recall sending a car to go get her. Yeah. Because what does this say? So sad. This is truly sad. Oh yeah. On or about, it says defendant Allen contacted her to invite her to his home and visit him in New Jersey. So this is what he's saying, is that he didn't call her, but yes, I did send over an Uber to come get her. He denied allegations and it's a lot of paragraphs, He denies allegations of paragraph 5, except to admit that the defendant Allen did not participate in any of the essay of the plaintiff. 10, except to deny being an antagonist, defendant Allen admits the allegations of paragraph 10. Oh, we really gonna have to sit here and go through this. What does paragraph 10 says? Defendant Allen is a social media antagonist and commentator, primarily known for his presence of platforms like YouTube, Instagram, and Twitch. Allen is a current resident and domicile of the state of New Jersey. Oh yeah. So jurisdiction, So he just goes through. So what he's doing, or the attorney, I should say, they're going through each of the paragraphs and they're saying, okay, we admit that, or we deny this. Okay. So anything of this nature. So let's look at 19, for instance. So 19, defendant admits the allegations of paragraph 19. So if we go to paragraph 19, it says, according to Ms. Abashi, she met Mr. Allen online via social media on or about 2021. She began casually dating him, and he periodically invited her to his New Jersey home. All right. So that's what they're doing. They're going by paragraph and either denying or admitting to the allegations that is listed in there. Sometimes if it is a tricky line or language in that verified complaint, they'll either say that the defendant doesn't have enough knowledge to know whether this is true or not. And it's crazy, but that's the typical language that you will put in there. So just like you see with 26, it says defendant is without knowledge sufficient to form a belief as to the truth of the allegations of paragraph 26, and plaintiff is left to her proofs. So meaning that she has to be able to prove that whatever she's alleging actually happened. So this is that. Let's go to trying to find the affirmative defenses. Mind you, this was a lot. Oh, he denies. Well, I'm pretty sure he ain't going. All right, so affirmative defenses. Let's see. They're saying that the accident and or injuries allegedly sustained were caused or contributed to by the negligence of the plaintiff, and the plaintiff's claim accordingly is barred or diminished by application of comparative negligence statute. So they're always going to go back on the plaintiff. This is standard language when we regarding any type of answers or general denials to any type of complaint. So it's like, okay, the plaintiff caused or they have contributory negligence in the claim. Let's see. And then it says the accident injuries allegedly sustained were caused and or contributed by the acts of third persons over whom the defendant had no control. So it's not saying that, DJ Akademiks was the cause, but they're saying it's the cause of a third party. So those two dudes that was there, that's how she got the injuries, but he does not have control over those two individuals. All right. He didn't have any type of contractual duty. Let's see what else. The defendant is entitled to set off and or a reduction of any damages award pursuant to the NJSA. So pretty much all of this is just really saying that if any injuries were sustained, it's the plaintiff's fault. If any injuries were sustained, is because of her acts. If any injuries were sustained, it was not DJ Akademiks' fault. It was pretty much the other people's fault, and he doesn't have any control of them. Okay. Let's see. Claims of the plaintiff are barred by reason of lack of personal jurisdiction over defendant. Let's see. The court is not a proper venue for this claim. Plaintiff's claims are frivolous. Wow. Answer to all cross claims. Defendant denies each and every allegation of all the cross claims filed against him. So if she does respond to this, he's denying all the allegations in that. It's crazy. It says also that defendant demands contribution from the co-defendants pursuant to the Joint Tortfeasors Contribution Act. Indemnification. And he's requesting for a jury. So this is his answer. He denies to some things, he admits to some things, and he provides a statement that it's not enough information to, say whether I admit to this or deny to it. And pretty much, once again, like we've seen in the Zeus Networks case with Barksdale, is that they are going to place the blame back on the plaintiff or the third party that he has no control of. So that is his answer, and it was filed on 9/11. Now it's 10/7, so it's been almost a good month. So I'm just trying to figure out what Mr. Tyrone is doing now. Even though I can't see this on the docket or you guys can't see it, it does not mean that nothing is happening. I'm pretty sure since the answer has been filed, I know for sure that they need to serve the other parties. Let me see. Well, first of all, they got to figure out who John and Jane Doe's are. So those other two individuals, we got to figure out who they are. In order to do that, you have to go through the discovery phase. So I'm pretty sure that Mr. Blackburn has sent DJ Akademiks attorney a request for interrogatories that has a list of questions. And I hope some of those questions is asking who were the other two defendants at the party. And once they get that information back, then they can amend the complaint again to add those two defendants there. They're probably going to request for what is called is a request for production. So any videos, surveillance videos, so on and so forth, paperwork. Now, from my understanding, if I'm not mistaken, in the complaint, it did say that the police department did have the surveillance footage, and that's the reason why I believe DJ Akademiks was called to the police station. So hopefully Mr. Blackburn got all of that. I sure hope so. And so pretty much we are at the discovery phase where this is going on. So the same way that Tyrone Blackburn is requesting certain information and documents from DJ Akademiks, DJ Akademiks attorney is also requesting certain information from the plaintiff. So it's going to be a while. I think discovery is going to take more than 30 to 45 days. More than 30 to 45 days. And then at that time, we'll see depositions. So we're not going to see much movement on the docket other than if they file like a certificate of written discovery showing that discovery was, sent to the other party, or if they do like a notice of deposition saying that, hey, we're scheduling depositions on this date. But other than that, I don't think we're going to see much movement. But I am going to keep an eye out to see if that is going to be the case. The next case is the dog bite case, and I believe it is the same situation. It looks like DJ Akademiks is taking care of business, but yeah. Let's see. Nope. Nah. Nope. So here it shows that and this is what I want to show you guys. So this is a dog bite case that not a lot of people are talking about. So a petition was filed on January 24th, 2024. She did try to make a effort to get him served. Now, because they were not able to serve him, they had to do a motion for substitute service. And you see this right here. This is what I was saying. This is very important. That's why I was like, I don't know if New York has something totally different. But if you're not able to serve them personally, you have to get an order from the court to say, okay, you can serve them this way. So that's crazy. Let me see, affidavit of service. And I just want to kind of show you guys. There we go. Here's the photos. This is what it's supposed to look like. Okay. This is what it is supposed to look like. Now, you're telling me in that other case that you didn't get no papers. Now, what is this? This look like a food delivery. So you go out that front door. And then you're saying that on the side of your house, I don't know which side, papers just ended up, a whole stack of papers just ended up. Make that make sense. Make that make sense. I want to see security footage because I know you got security footage. And I'm pretty sure security footage show somebody walking up to your door and placing that paperwork on your door. Okay. So anywho, they actually have pictures showing that they served him. Now, on the 15th of July, default has been entered against him because he did not answer. He did not answer. He decides to answer on the 26th. Let me see what this consent order is. Oh, this is another one. A consent order vacating the default of judgment and extending time to answer for 30 days. You know, the way that the law is set up is crazy, yo. It is really crazy. So pretty much because the defendant wants, and I'm not saying that this is a bad thing, but it is crazy. Sometimes I just feel like these courts got to stand on business. You are supposed to respond in a certain time. You fail to respond in a certain time. Why can't we just move on with the default judgment? Why? But the judge said, hey, I'm going to go ahead and void the default judgment, and I'm going to give you enough time to file an answer and respond. And that's what he did. So July 26th, he did that. And I explained that in the other video as well. And I believe I probably already went on there. So it's not much movement on this case, only because they're probably still in the discovery phase, trying to collect more evidence and, reviewing all the documents. And they're probably setting up depositions and stuff like that. So I believe I've already gone through this where he denied, he pretty much put in his separate defenses. They always say that the the plaintiff is responsible for what happened to them themselves, which is crazy. Yeah, so it's not too much. It's no movement on this one, as far as we can see. But like I said, they are in discovery, hopefully reviewing, collecting evidence and reviewing the evidence, and hopefully they can get this mediated. But this is crazy, though. This is crazy. So as of now, I don't see him having any other cases with anybody else. I hope that, the judge has given him an opportunity in 2 cases to, answer and pursue this case and defend himself, in which I wouldn't. Like, you failed to respond, you just gonna have to deal with this default judgment. See, in Texas, oh man, nah. If I file a default judgment because you didn't respond, I'm on it. I'm on it. Like, I sit there and I calendar, like, okay, you don't respond in 20 days. On that 21st day, I am filing my default judgment, and I am pushing to ensure that that goes through till the end, till I get my judgment. So with New York and New Jersey, they're giving them opportunities to defend them cases, I guess. Do y'all think that this is right? Do y'all think that these women should be entitled to their default judgments? What do you think? Tell me in the comments below. Don't forget to like, share, and subscribe. Until then, be blessed, and I am out. Bye.